Okay, we're in business, guys. Welcome everyone to today's program, Wills, Trust, and Estate Planning Basics. Today's program will last approximately an hour. At the end, I'll open it for questions and answers, but please hold your questions until the end of the program. If you have a phone, please make sure it's on off or vibrate. If you need to take a call or speak to somebody, please speak to somebody outside or wherever the library allows you to do so. And also, please no speaking or talking during the program other than your presenter. So what else can you expect from an attorney? There's a little bit of a disclaimer. Today's program is for informational and educational purposes only. Nothing that you hear today is or should be considered legal advice. If you do need legal advice, you should see an attorney in his or her office. So while today's program is on wills, trust, and estate planning basics, I want to speak to you about what most of my clients are generally coming to me to try to avoid. And this is what we refer to as probate, or specifically probate for decedent's estates. And what is probate? Well, for those of you who are very familiar with what the probate process is, I'm sorry. But for those of you who are a little less familiar, it's the court process for distributing a deceased person's estate. So if you die and you have $150,000 or more in total that's not in trust, that doesn't list named beneficiaries or co-owners who survive you, or if you have any real estate that's in your name, probate's going to be required. It's not to say that there's litigation, although there could be, but the court wants to ensure if you have not properly planned ahead, there's a plan in place. So in the event of your death, your creditors can be paid and that your beneficiaries can eventually receive their monies. And probate's not the end of the world. Plenty of estates wind up going through probate, but most people would generally want to avoid probate because of the time and the expense. Probate takes a minimum of 6 months, not from the time of your death, but from the time the estate is going to be opened and publication is made in the newspaper to unknown creditors or unknown heirs and creditors. Although I'd say your average probate estates usually open about a year to a year and a half. It may take a little while to make sure taxes are paid, as well as sometimes acquiring some different types of assets, particularly bonds, can be difficult, etc. And a house also might need to be sold, or real estate, or a business, etc. And it's, as I said, about a year and a half, assuming no issues, no litigation, no major problems, no difficult to evaluate assets, etc. There's also the expense. I'd say going through probate is going to be about 3 to 5 times the cost, as opposed to planning ahead to avoid it. Now, as I said, plenty of estates wind up going through probate. Just most of my clients would want to avoid it to make it a smoother and easier and more cost-effective process for their friends, families, charities, etc., when they're no longer here. Now, some people will say, well, Jacob, I really don't care about what happens to my assets when I die. Of course, if that's the case, I don't know why you're attending a program on wills and trusts. But there's something most people are much less familiar with, and this is what we refer to as guardianship, or guardianship for disabled adults. Now, most of us don't like to think about dying, let alone becoming disabled. And maybe if you thought about becoming disabled, and by disabled I mean being incapable of making your healthcare and or financial decisions, you'd assume my spouse could make these decisions for me, my wife or my husband. Or maybe my adult child could make these decisions for me. Or maybe I could make decisions for my adult child who's living at home while working, going to school, etc. People find out the hard way that is not the case. If you have not properly planned ahead, your only avenue to make decisions for somebody else, or for somebody to make them for you, is guardianship. And unlike probate that I said is usually over in about a year or a year and a half, guardianship's going to last from the time of somebody's permanent disability until their death. So if somebody is disabled for 5, 10, 20, 30 years, that's 5, 10, 20, or 30 years of ongoing court costs, attorney fees, accountings. And if somebody wants to do anything out of the ordinary, like sell your house, move you into assisted living, move you out of state, they're going to have to get court permission for all of these different decisions. If you don't get anything else out of today's program, you do want to avoid guardianship at all costs. It's not very difficult to do, but there is a correct way of doing so. Now, for somebody that already knows somebody that is over the age of 18 and incapable of making his or her own decisions, very important that you start the guardianship process as soon as you can. There's no way to undo it once it's somebody's already in that situation and an adult. But I've had a lot of people who said, well, I've already, been making most of my parents' decisions or my child's decisions or my spouse's decisions. Well, in the event of an emergency, somebody needs to go to a hospital, you need to access any of their funds, you're going to have to get a guardianship, and you might as well just get it done as soon as the situation calls for it. The same thing for probate. If somebody has already passed away, you need to start doing it earlier rather than later. One of my clients who I did a will for years ago, she called me a month or two ago and said, yeah, well, I didn't tell you, but my dad died 30 years ago and we still haven't ever gotten, reached the assets. I said, yeah, we should probably open up a probate estate for that. Now, I like to call this program Wills, Trust, and Estate Planning Basics. I found if I just call it estate planning, a lot of times people will say, well, I don't have millions and millions of dollars. Do I really need an estate plan? Well, for the purpose of today's program, an estate just means everything that you own. I've worked on estates that have been $2,000 or less, where I've had clients on Medicaid. I've worked on estates up to $20 million and pretty much everything in between. But there is no one-size-fits-all plan. I see a lot of advertisements on TV, on the internet, etc. Well, you just need these particular forms. You can do this, fill it out, and it'll do everything. It's good in every state. Well, bad in every state. Estate planning laws are very particular. And an estate plan, no matter how simple or complex you think your situation is, or no matter how much or how little money you think you have, your estate plan really should be tailored to your individual needs and circumstances, your health care, your finances, what you want to accomplish, as well as potentially the needs of anyone or anything you may be leaving your assets to upon your death. Estate planning is not just about who gets your money when you die. While that's a component of it, that's not the only component of it. Estate planning is really a process where individuals can determine who will act on your behalf if you become disabled, who's going to make your healthcare and financial decisions. If you have minor children, who's going to care for them? Where are they going to live? Who's going to manage their money for them until they're adults? And also, who will receive your property, assets, etc. upon your death? Will those individuals receive a lump sum all at once? Will they just receive a stream of income over their lifetime? Will they receive it at different ages or in different increments at different milestones in their life? Also, what's equally, if not more important to a lot of my clients, is there anyone related to you that you want to ensure will never receive your assets? Now, while some people laugh at that, this does mean if you haven't done any planning whatsoever, it's very possible that that no good brother or sister you haven't spoke to for the last 20 years may be receiving all or some of your assets upon your death. Now, the basic estate planning documents are wills, trusts, powers of attorney for healthcare, powers of attorney for property, and living wills. Does that mean everyone needs all of these forms? No, this is a general program today. These are the forms that apply to most people, but some of you may need more forms, some of you may need less forms, and depending on how the forms are drafted, they may be doing vastly different things as opposed to the person sitting next to you or somebody else that you may know. So I'm going to go over these different forms, and I'm going to try to give a few examples as we go through the process. So the first thing we'll speak about today is a living will. A living will does not deal with the disposition of your assets. A living will is really a healthcare form. It says if I have a terminal, irreversible, or incurable injury, don't try to save me. Now, that's all this form is. That's all it does. And if your medical provider has this form ahead of time and you do have an underlying terminal illness, they are not supposed to hook you up to artificial life-sustaining equipment, things like feeding, respirator, hydration, if they have an underlying terminal illness. And living wills were in the news a number of years ago. If anyone can remember a young lady named Terri Schiavo. She was in her late 20s, early 30s, probably never thought about dying, let alone becoming disabled. But for close to a decade, she was in a coma, with her parents in the court arguing that she should remain on life support, and her husband arguing that she should be taken off life support. After close to a decade, she was removed from life support after a lot of time, a lot of money, a lot of grief. Perhaps if she would have had the appropriate paperwork in place, a lot of that time, grief, and money could have been saved. Now, does everyone need a living will? Absolutely not. This is one that's more of a matter of personal choice. I have clients in their 90s who don't want it. I have clients in their 20s who do. I have married couples who come to me. Sometimes one spouse wants it, one doesn't. There's no right or wrong answer. But probably the most important form I'll speak about today is going to be the power of attorney for healthcare. Because in this form, you can appoint somebody to make medical decisions on your behalf. One person at a time, as many people in succession as you'd like. You need to choose at least one person, but it's usually a good idea to choose two or more if you have them available. But when you're choosing this person, make sure you choose the right person for the job. Don't arbitrarily choose them because they're married to you or because it's your eldest child. If that person's emotional state, personal or religious beliefs are very different from your own, that may not be the right person for you. So you need to choose and choose accordingly. Also, as I pointed out, for most people, as I said, you need at least one person. But assuming you're not relatively young yourself, it's a good idea if you can have one person who's maybe in a younger age group. Because if you're 50, 60, 70 years old, and the only people that you've named have been people around your age range, like a spouse or a brother or a sister or a friend, well, guess what? By the time you're 70, 80, or 90 years old and you need them, they'll be just as old, if not older than you, and they might not be able to do it. So choose and choose accordingly, but really give it some thought before just inserting somebody's name. Now, the next form I'll speak about today is the power of attorney for property. This is not power of attorney for real estate. This is really power of attorney for finances. And in this form, you can appoint somebody to make financial decisions on your behalf. Also, one person at a time, as many people in succession as you'd like. You need at least one person. I strongly recommend two or more. Just make sure whoever you choose is honest, trustworthy, and good at easily and quickly paying bills, because that's what you're going to need that person for. Now, some people will say, well, Jacob, the reason I never did my estate planning, I never did a will, a trust, powers of attorney, it's because I don't have any close friends or family, or while I have close friends or family, I really don't have anyone that I think would be good for this job. If that's the situation you're in, I'd argue you really need to do estate planning probably more than anyone else. And if you work with any good estate planning attorney, we all have lists of people that you can hire for a fee, where you can appoint them to make healthcare and or financial decisions on your behalf. For healthcare, it might wind up being a social worker. For finances, it may wind up being a bank or a trust company. And some people say, well, I don't really like that. I don't want something so impersonal. Well, if you do have a close friend or family member that has a good choice, by all means, choose them. But if you really have to think about it, if it's just going to be that niece or nephew you speak to once or twice a year, that might not be such a great idea. And let me explain why. Because a number of years ago, I was talking to one of my colleagues who was a banker, and he had a client. She was an elderly woman, didn't have many close friends or family, but she decided she'd do a power of attorney for property on her own without any legal guidance. And while she didn't have many close friends or family, she did have one close friend who she had known for the last year or two from church. Well, this banker went above and beyond what most would generally do. He decided to do a search on the internet for this lady's good, honest friend. And the good thing he did, because this lady's good, honest friend from church had multiple felony convictions across multiple states for stealing money from the elderly. This is not a one-time occurrence, I assure you. There are all types of scams out there. I know, I get calls. Apparently, my nephew is in jail and he's in Mexico and he needs bail from me. Well, I'm an only child. I'm pretty sure I don't have a nephew who's in jail in Mexico. Apparently, if I don't pay the IRS $50,000 immediately, I'm going to prison myself. And only a few weeks ago, some idiot tried to wash a check of mine. My bank called me and they said, it's a rather large sum of money. It's kind of out of character and it doesn't look like your handwriting. I said, yeah, that's not mine. So now I'm busy changing a checking account. But the point is, there are all types of fraudsters out there. There are a lot of people, their full-time job is to try to deprive you or me of our money. So you may need to protect yourself from your future self. Also, oftentimes I get a number of questions such as, at what point in time in my life do I really need to start doing my estate planning? Is it when I retire? Is it when I have my first grandchild, my first great-grandchild? If you've ever seen my program before, you know the answer. You need to start doing your estate planning after you turn 18 and before you die or become disabled. If by all means you know when you're planning on dying or becoming disabled, let me know. We'll try to do it the day before. But realistically, this is not something you want to try to put off, because oftentimes I or one of my colleagues, we're getting a call during an emergency. Somebody says, my husband, wife, brother, sister, mother, father, it's an emergency. We need to get something done. They're in hospice. They have cancer. They're going into a nursing home. Well, in a situation like that, it can be very stressful. If they're doing something out of the ordinary, such as maybe giving one child more money than others, it can be more easily contested. The attorney usually is going to want to try to make sure this person can still make their decisions. And if you want some attorney to drop all of his or her work and come and see you, be prepared to pay a little bit more of a price tag for somebody to do that. So that's not a good way to approach your estate planning. Needless to say, every year I still wind up getting those calls every year and wind up doing it. But nonetheless, it would be much better if people planned ahead. And the theme of today's program really should be don't wait until it's too late. I had a few clients who came to me. They were doing a relatively simple estate plan, just a will and powers of attorney for healthcare and property. And I called them and I said, well, your forms are ready to be signed. When do you want to come in and sign them? And the husband said, well, we'd like to come in about 6 weeks. I said, 6 weeks? Why do you want to wait so long? And he said, well, we just have a lot of things going on, friends, family, vacation. And by the way, next week, my wife is going in for some minor surgery. I said, minor surgery? And he said, oh, nothing to be concerned with. This is a simple outpatient procedure. And I still repeated, but you've already paid me what you want to do it ahead of time. He said, thanks for your advice, Jacob. We'll call you in a few weeks. Well, 6 weeks passed and the husband called me, but this was not the phone call I wanted. He said, well, my wife was recovering from surgery, but there were some complications. There were additional surgeries, and now she's in a coma. The doctors are asking for her power of attorney for health care so I could make her medical decisions and get her medical records. And by the way, all of the money she has, it's in an IRA. I'd like to use that to pay for her care. But you've got these forms already done. We can use those, right? Well, of course not. She didn't sign them. They weren't witnessed. They weren't notarized. So we had to go into court, get the husband appointed as the guardian. She lived for about 1.5 years and died with approximately $200,000 left in her IRA. Fortunately, she had listed beneficiaries. But unfortunately, those beneficiaries were her parents, who are long since deceased. We had to go into probate. And as opposed to that money growing tax-free and having my client or the husband take that money out over his lifetime, everything had to be paid at once, and all of the taxes had to be paid at once. But it's not enough to start your estate planning. You have to finish it too. And unfortunately, I think a lot of individuals, as well as a lot of attorneys who don't really do this all the time, they approach estate planning in the method of, well, you've got your will, your trust, your powers of attorney, and you put it away in a desk drawer or a safe deposit box for 5, 10, or 20 years. That thing has not seen the light of day. You don't even know what it says. It's on yellowed paper. It probably has coffee stains on it, if you can even find it. That's not a good way of approaching it, because these forms really should be updated if there have been changes in your personal circumstances, your healthcare circumstances, your financial circumstances. I had one client who called me. He said, Jacob, I was your client. And I said, yes, I remember you. He said, well, I haven't talked to you for about 10 years, but since then, my wife had died. I've gotten remarried. And when I talked to you, I was worth about $1 million, and now we're worth $6 million, and I moved my address. I said, okay, yeah, that's about every change that we could possibly think of. The only thing that could be more would be if you had or adopted more children. That would be the only thing you could have possibly done to warrant more changes. I also was speaking to a couple of my clients. They called me on an unrelated matter, and I said, okay, well, as long as you're calling me, let me look at your forms. I see on your power of attorney for healthcare, you and your sister, keep in mind these ladies are both in their 90s, had named each other as their primary decision maker for healthcare decisions. But I said, at least you have a friend as your second choice. And one of the sisters chimed in and she said, oh no, our other friend is deceased. I said, well, we should probably update your power of attorney for healthcare and put a secondary choice for each of you after your sister. That might be a good idea. And guess what? Even if nothing has changed with you or your personal or financial circumstances or the people you've named to make your decisions, guess what? The law may have changed. I can guarantee you if your powers of attorney for healthcare and or property are older than July 1st of 2011, they do not comply with the current law in the state of Illinois, because this is when the state of Illinois updated the Illinois Power of Attorney Act. And there were a number of important changes. First, they revoked prior powers of attorney. What does that mean? Well, if you did a power of attorney for property in 2008 and you properly executed a new one in 2010, you'd assume the one you did in 2010 is the only one that's good. Could be wrong. It could be legally argued. They're both still valid. However, if you're using the correct up-to-date form in the state of Illinois and you properly executed one last week and then you properly executed a new one today, the one that you executed today is the only one that's legally valid. There's a cover page, a little wordier than I think is necessary, but it says by signing this form, you're appointing somebody to make financial decisions on your behalf. You don't have to sign this form, but if you don't sign it, it's obviously ineffective. And if you do have questions regarding this form, you should have an attorney explain it to you. Also, the power of attorney for healthcare. In this form, the new form, compliance with HIPAA, the Health Insurance Portability and Accountability Act of 1996. What is HIPAA? HIPAA is federal privacy law. If anyone can remember way back when you went to the doctor, they would hand you a sheet of paper. It would say under federal law, we cannot release your medical information without your written consent, etc. These days, you usually tap a screen. That's usually part of what it says. So does that mean an old power of attorney for healthcare is invalid? No, the person you've appointed to make your medical decisions can still do so. It just means under federal law, your medical institution or doctor is legally prohibited from giving them any of your medical information. Slightly problematic to say the least. But if you're using the correct up-to-date form in the state of Illinois, you should not have to worry about that. And some people will say, well, I've done my forms after, then I'm fine, right? Well, perhaps not. The state of Illinois updated the power of attorney for healthcare yet again, January 1st of 2015. The reason was a lot of attorneys really felt the power of attorney for healthcare was too legalese. It's pretty common where somebody's getting this form for the first time during an emergency. They're going into a nursing home, they're entering hospice, they've got an upcoming surgery. The new form is meant to be more efficient and simple. It's only about 6 or 7 pages. It's actually written in English. You should be able to understand it if you take the time to read it. Sorry, I thought I had advanced that. It also asks a number of good questions that you should consider, such as what do I want my agent to know? What decisions can my agent make? Who should I choose as my agent? What do I do with this form? And what happens if my agent does not act? The agent is the person that you've appointed to make your decision. I'll also point out the best thing you can generally do for your estate planning, use an attorney who really focuses on this area all the time. If you choose to do nothing, probate and guardianship have been around for a long time. It'll continue to be around for a long time. But the worst thing you can generally do is to use an attorney who does not focus in this area of law or try to do it on your own, because it's going to be a lot more time consuming and a lot more expensive to try to undo something that has been done poorly. And let me explain what can happen. So a number of years ago when I had a different office, I knew another lawyer in my building, and I asked him if he wouldn't mind being a witness to a estate planning signing. And a few hours later, his secretary called me. She said, Jacob, the attorney I work for, he's never seen those versions of the power of attorney for healthcare and or property. Would you mind giving us a copy of your forms? And I said, sure. As another attorney I know, I'd be happy to give you a copy of my forms. But that meant for the last 10 years, he had been giving all of his estate planning clients forms that did not comply with the current law. Now, it's not to say this wasn't a smart lawyer. He was a brilliant guy, but he did a little bit of everything. He did international business law, he did divorce, he did murder trials, he did bankruptcy, real estate closings, you name it, he had probably done it. At the same point, there's no way you can keep up on every area of law. and that's why he didn't know it. I also had a few clients who came in, they were actually criminal law attorneys, and they said, well, one of our friends did our powers of attorney for healthcare and property, but he was a general practitioner. They were actually, as I said, criminal lawyers. And I looked at it, I said, well, you signed it in 2018, but this lawyer was using the pre-2011 forms. And actually, just earlier this week, I had a few clients who had powers of attorney for healthcare and property, and they said, well, we did it on our own, and this is what the hospital gave us when my husband was sick, and we just filled them out, and we don't need you to do these forms. I said, I can't do your estate plan without doing them because you don't know it, but you filled out these forms incorrectly, and if you ever actually needed to use them, they're not going to work. So choose accordingly, but you do need to make forms. You're sure your forms are done correctly and that they are up to date with the current law. Now, on to something most of you have probably seen before, but you may or may not understand what it actually does, and that's a simple will. Simple wills give beneficiaries assets outright. They usually still wind up going through probate, and then information is available to the public. And a lot of times people would say, well, why would I even want to do a will if this needs to go through probate? Well, much better to have a well-drafted will, or at least a will and powers of attorney, than not having anything. For most people, a will in a trust or a will in some other type of vehicle may be fairly beneficial, but it's a case-by-case basis. I've had some clients who I said you only need a will, and some of my clients, while I recommended other things, they said all I want is a will, and that's fine. But there are a lot of benefits to having a well-drafted simple will, because in a simple will, you can appoint who your executor is. The executor is the person that when you die is going to be responsible for gathering your assets, hiring an attorney to take your estate through probate, paying off your rightful creditors, and then distributing your money to the rightful beneficiaries. You can also name who those beneficiaries are, because if you don't have a plan in place, the state where you live has a plan in place for you. For the state of Illinois, it's called the Illinois Probate Act. And while I cannot go through the entire act, I will go through a small excerpt of it. Because at least for any assets that are not in trust, that don't list co-owners or beneficiaries who survive you, well, the way the Probate Act works is it says if you're married and you have no children, those assets all go to your spouse. If you're not married and you have children, approximately half goes to your spouse and half goes to your children. However, if you are married and you have children, approximately half goes to your spouse and the other half goes to your kids. And this can be a very rude awakening for a lot of people, especially if you've never checked on who owns your assets, or especially who is on the deed to your house. I know of one situation where there was a husband and a wife, and apparently what had happened was the husband had died and they had 2 adult sons. Well, the wife assumed, like most people, that their house was owned jointly between them. But apparently it was solely in the husband's own name. I don't know why. Maybe he inherited the home from his parents. Maybe he had better credit when he bought the house. Maybe he owned it before they were married. I'm not sure. And one son apparently said, don't worry, Mom. I know Dad would want you to have the home. I'll sign over my interest to you. The other son had a different idea, realizing if he didn't get his inheritance now, he may never get it. And he said, I'd like my 1/4 interest of the house. And as a 1/4 owner, he was able to force the sale of the home, and the mother had to move out, and she and her son never spoke to him again. But that can be the price to pay for not doing any proper estate planning. Also, over the years, I've worked with one of my colleagues who's a very good personal injury attorney. Oftentimes, I refer to him if one of my clients or friends or family members has been seriously injured, and he oftentimes refers to me if one of his clients has died and we need to open up a probate estate or we need to open up a guardianship estate because somebody has become disabled. And oftentimes when I talk to the person who wants to bring the lawsuit for personal injury or wrongful death, I have to ask them, okay, well, I see, your father passed away. Well, did he have a will? Well, no, he did not have a will. Okay, was he married at the time of his death? No, my mother predeceased him. Okay, well, do you have any siblings? Well, yes, I have a sister, but she hasn't spoken to me or my dad for the last 30 years. She doesn't count, right? Well, oh no, that's not the case. And now because your dad didn't think he needed a will, we have a $1 or $2 million settlement and she's going to get half of it. I've had a lot of clients who have died during different circumstances, and their estates have been worth a lot more or a lot less than they ever anticipated. If you did your planning when you had a lot more money or the laws were different, sometimes the documents need to be changed because they don't need to be as complex. But I also remember I had one client, she was on Medicaid, and I just did powers of attorney for her. Well, a month or two later, her daughter called me and said, my mom has been in a horrific bus accident. She's now a quadriplegic. And we were able to get a will signed, fortunately, while she was still cognizant. But this lady who had less than $2,000 to her name, and she hadn't had more than $2,000 to her name for probably the last 20 years. Well, when she died, she had an estate of $1.5 million due to that lawsuit. So you can always have a will without having a trust, but you should never have a trust without having some type of will accompany it. If you have a simple will, that's usually going to be your main document. But if you have a living revocable trust, your will is generally going to be a supporting document, and it's usually going to be called a pour-over will. There's only a few differences, but there's one major difference. So for me, as I said, a simple will would say if I die, everything goes to my wife. If my wife doesn't outlive me, everything goes equally to our children. However, for a pour-over will, assuming I have a living revocable trust, it'll say everything that I have when I die goes to my trust, and my trust will distribute it. It might say who gets personal property, things like clothing, furniture, cars, jewelry, etc. But then it transfers the rest of your assets to the trust. Because one way or another, in order for your trust to work, your assets have to get into it. And let me explain the price of not knowing what you're doing if you're doing estate planning. Because one of my clients, she called me because both of her parents apparently had died, and they had a trust that was drawn up saying she was supposed to get 70% of the estate and her brother was supposed to get 30% of the estate. And I said, well, just do me a favor. Before you see me, call the financial institution where your parents had all their money, see if that money was owned by their trust, or see if those accounts had named beneficiaries. And also, by the way, if your parents had a will, you should bring that into me. Well, when she came into me to see me, I said, okay, well, I see your trust, says what you think it says. But I said, okay, are the assets owned by the trust? No, they're not owned by the trust. I said, okay, well, if they're not owned by the trust, were there named beneficiaries? No named beneficiaries on the account. I said, at least tell me your parents did a will. Well, they did a trust. They didn't think they needed a will. Well, now because we don't have a will, we wound up going through probate, half of the assets going to the sister and half to the brother, not 70% to the sister and 30 to the brother like the parents wanted, but that can be the price for not doing things correctly. And for people who think they can do a trust on their own, if anyone ever takes a self-drafted trust or a trust drawn up without an attorney to a court in Illinois and somebody wants to contest it, the judges will routinely ignore any of the terms or conditions of the trust, saying that's a sophisticated document and the person signing it probably just really didn't understand what they were doing. And on to the most complex area of today's program, which is a living revocable trust. Now, it's called a living trust because it's created during your lifetime. It's called revocable because you could always change it. If I drew up my trust today and it said everything goes to my wife, and if she doesn't outlive me, everything goes equally to our 2 children, well, if we had another child, I could amend it for that. If I wanted to amend it in a few years and say I want to give 10% to charity, I could do that too, etc. And this is not the only type of trust. There are land trusts, there are irrevocable trusts, and depending on how any trust is drafted, it may be doing vastly different things. But this is probably the most common type of trust and the one that's usually going to be most beneficial to the majority of individuals. And if used correctly, it can be used to avoid probate and guardianship, but if it's not used correctly, it's just paper. And let me explain why it can be used to avoid probate and guardianship. So I tell my clients, at least in this respect, think of a living revocable trust like a small corporation. A small corporation can own things. It can own real estate, it can own bank accounts, etc. It's usually controlled by the president. But if the president dies or becomes disabled, there's usually a vice president that just takes over and continues to run it. The same principle applies to a living revocable trust. If you die or become disabled, your trust doesn't. Somebody just takes over the management of it and any of the assets that are in it. And that's why probate and guardianship can be avoided for the assets that are in it. It also can be used to keep information private. Now, on my prior slide where I was talking about a will, I said if you had a will, your assets would most likely go through probate and information is available to the public. If your assets wind up going through probate, anyone can find out how much money you had when you died and who it went to. And some people will say, well, what do I care? I'll be dead. Well, you really should care, and let me explain why. Because I got a call from somebody who was very frantic. Apparently, there was an issue with his mother. What had happened was several years prior to this, the father died, but he only had a simple will. He had a substantial estate, but his estate wound up going through probate to his wife. And after a year or two, the wife decided she wanted to move on with her life. And she met a very nice, sophisticated, handsome gentleman. After they had been dating for about 6 months, he gave her a very nice, sophisticated business proposal. One that didn't just require some of her money, one that required all of it. Apparently, her children said, what do you know about this guy? Don't trust him. And apparently, her response is probably pretty similar to what our parents would have told us or what we tell our children, which is, I'm your mother. Thank you very much. I think I can make my own decisions for myself. And sure enough, she gave him that loan, and she found out he was truly, deeply, and madly in love. Not with her, but with her money. We don't know who he is. We don't know where he is. The money is gone. There's no way to get it back. And a lot of people would say, well, why would you give me such a stupid example? I would never do anything like this. Well, as we get older, we might be a little bit more susceptible to undue influence. Somebody might be able to convince us to do something we wouldn't have done when we were younger. Also, can anyone in this room say you never dated the wrong person, fell in love with the wrong person, sometimes even married the wrong person? And you may need to protect yourself from your future self. Also, if you're in a relationship, I don't care if you're married or unmarried, for whatever reason, in most relationships, usually one spouse is managing all of the money. They're the person taking care of the investments, they're paying the bills, etc. Unfortunately, that's almost always the person who dies first. Those of you with your significant other are thinking about him or her today, you might say, thanks, honey. I know that'll be you. But all joking aside, you may not leave him or her only with the grief of your passing. You may leave him or her with a huge financial responsibility that he or she will be completely unprepared for, and the money can go very quickly. Actually, I remember the first case I had, believe it or not, it was one of my clients in Morton Grove. And he called me because his wife died and he really needed some help. Apparently, they had estate planning documents drawn up, wills and trusts. They were very well drawn up for their situation 30 years ago when they did them. And at that time, they were in their late 50s, early 60s. The wife had managed all of the assets. And not to say that the husband wasn't a smart guy, he was an engineer, but at the age of 93, it was just a little too overwhelming for him to try to have to deal with the assets. Every time I met him for estate planning, he tried to give me a box that had financial statements and bills. I said, I'm just your lawyer. I can give you somebody who can help you, but fortunately, at least he was willing to ask for help because most people generally don't. And we were able to make some changes and get somebody in, and we were able to get a trust company in, and the trust company was able to make sure his property taxes were paid, income taxes were paid, final income taxes for his wife. When he moved to assisted living, they made sure those bills were paid. They made sure the lawn was cut, the snow was shoveled. When he died, they did his final return. They sold the house. They did everything. So it did make it a lot easier. The only thing that wasn't so easy, apparently his wife, as far as investing went, she had a lot of money invested in CDs. But she was a CD shopper. She was always looking for the best rate. When she died, she had CDs at more than 30 different financial institutions. She kept great records of these. She kept them up here. It took me, a CPA, a financial advisor, and a trust company more than 2 years to find out where she had squirreled away all of her money. And while a lot of people would point out, yes, you can find those on a tax return, well, only if you made a certain amount of money and only if you actually reported them. I'm sure the CPA had a lot of fun with that accounting later on, too. And this is where we get to the last bullet point. You can give income to a beneficiary without giving them control. In her case, she could have just said, if something happens to me, a separate trustee could basically provide for my spouse to make sure this doesn't happen, and it would have been a lot less stressful for him. Also, this can be used for a number of different situations. Because what if you want to give money to a young adult child or a minor child? Well, if you have not properly planned ahead, that means they're going to get all of the money when they turn 18 or 21. Now, most of us can remember when we were 18 or 21. If you would have received $20,000, $5 million, would your first thought have been, I'm going to use this money to provide for my education and invest for my retirement? Probably not. We don't make the best decisions as young adults. While I was fairly mature at the age of 18, I did grow up watching Magnum PI. I would have loved the red Ferrari. So for reasons like that, oftentimes it might say, in case something happens to me, there's a separate trustee, he or she or it can provide for my children's health, education, maintenance, and support. Maybe they'll get a third at 25, a third at 30, a third at 35. What if you want to leave money to somebody who's bad with money? Well, maybe you never want to leave them a lump sum. Maybe you want to leave them a stream of income. What if you want to leave money to somebody who has an addiction? Gambling, drugs, alcohol. For whatever reason, I've seen a large uptake in this for the last few years. So you can choose to give them nothing. You could give them a lump sum, but that's never advisable because the money will probably go very fast and they could actually use it to harm themselves. But you might want to say there's a separate trustee that has discretion to provide for what they need, but they can never demand the money in full. What if you want to leave money to somebody who is on Medicaid and or supplemental security income? Well, the problem is with that is if you leave them money, they're going to get knocked off. They're going to have to spend down until they have $2,000 or less and then reapply. And that could be catastrophic because I've had that phone call many times where somebody has said, well, my mother, father, whomever it was, died and now somebody's inheriting money, but they're in a facility being paid for by public aid. And oftentimes they have to move out. They have to spend down until they have $2,000 or less. And assuming it's not a large amount of money, that money might be spent in 1 or 2 years or even less than that. And if they're in a nice facility, well, if it's a nice facility, there may be a waiting list for 5 or 10 years to get back in, and they may not have a great situation with that. So if there is anyone that's closely related to you that is on public aid, you want to make sure you address that issue by A, either making sure you don't leave them anything, or B, depending on how much you may be leaving them and what the situation is, you may want to consider using a special needs trust. Now, these are fairly restrictive, but you can make sure that they still can receive their public aid, but the special needs trust, those assets can be used for things above and beyond what public aid will pay for. And I remember the first one that I did, it was for one lady. She was leaving everything to her disabled brother. And when she died, it was really used to enhance his life because it was used so he could go on vacations, field trips, to go to see a movie or a restaurant or for exercise equipment because public aid wasn't going to pay for it. And when he died, any of the money that was left over, it wound up going to the facility where he lived to be donated for the other residents who really didn't have anyone or any, funds of money beyond the public aid. So that can work very well if it's set up correctly and the correct and under the correct situation. Now, as I pointed out, the theme of today's program should be don't wait until it's too late. I had one client who came to me because his brother had died and he needed help with the probate estate. And as we were getting close to the end of it, I said, look, you've seen how long this has taken and you've seen how much this costs. Wouldn't you want to do a will and trust and powers of attorney so if something happened to you, we wouldn't be stuck with, all this time and all these expenses. And especially in his situation, because his parents were deceased, he was never married, had no kids, and his only sibling had just died. But I knew he had a longtime girlfriend for the last 20 or 30 years. And he said, yes, Jacob, that's a great idea. I'm definitely going to do my estate planning with you. But we're snowbirds. Every year when it starts to get cold, we leave for warmer climates. We're leaving for Texas in about 2 weeks. I guess if I don't have time to do my estate planning before then, I'll just have to live until I get back. Now, these are his own words. I cannot even begin to make this stuff up. But no shame on any of you who thought he died on that vacation. You're even more pessimistic than the lawyer in front of you. He did not die on that vacation. But about 3 months later, he called me and I said, are you back in the Chicagoland area? Are you ready to close your brother's estate? And maybe now could I talk you into doing some estate planning? And he paused for a moment and he said, well, I thought I called you a couple of weeks ago. I guess I didn't. I was having some terrible stomach pains. I had to go to the doctor. They had to remove a tumor from my stomach the size of an orange. By the way, could you do a will and trust and powers of attorney and send them to me here in Texas with instructions so I could get this done? I said, sure, not my preferred method of doing things, but we can do that. He came back to the area. I was able to transfer his house into the trust. And I said, look, I know you've got about $1 million. Did you put that in the trust like I told you to? And he said, yes, Jacob, of course I listened to you. Well, unfortunately, 6 months later, he died and he did not listen to me. He decided he'd listen to his girlfriend. Because why would you want to listen to your estate planning attorney when what your friends, family, or what you read on the internet will provide you with so much better advice? Apparently, she said, oh, you should just list me as a beneficiary. I heard if that happens, I don't have to go through probate, which is true, but you should never do so without your attorney's advice. Because she also said, but in case something happens to me, you should also list as a beneficiary my adult son and my 2 minor grandkids. So when he died, his girlfriend got the house. She got about $250,000. Her son got $250,000. Each of the 2 minor grandkids got $250,000 where it's locked in accounts. They can't touch it until they turn 18. Now, was this what my client wanted? Absolutely not. But that's what happened because he did not listen. And this can happen in emergency situations. I just had a client who died, and I told them, I always make my clients sign something in writing. I told you to put your assets into your trust. Well, he figured that he could just list his brother and sister as beneficiaries on everything. Well, he thought he listed them on everything. However, he listed one of his friends on what he thought was a small bank account, and sometime before he died, he transferred $500,000 to that. So now the friend is getting $500,000. Whether he meant it or not, I don't know, but that's going to be a major problem. So listen to your lawyer, even if you think you know better, or your banker or financial advisor has just told you this is what you should do. Don't listen to them. Listen to somebody who does this for their profession. I tell financial advisors and bankers, look, I don't give financial advice. You should not be giving your clients legal advice, because as much as you think you know what you're doing, you really don't. Let me give one more example before I move on. Being a lawyer, it's a legal requirement. You do have to like the sound of your own voice. So fortunately, this was not my example. This was something I read from AARP. Apparently, a couple did some estate planning, and in their trust, it basically said, they had 4 children, and at the time, they had a little under $1 million. They said, we give $200,000 to each of our 4 children. We give the rest of the money to charity. Well, by the time they died, 20 or 30 years later, they had $10 million. $200,000 going to each of their 4 children and $9.2 million going to charity. Now, was that the attorney's fault? Was that their fault? I don't know, but that is a good reason why you should look at your forms periodically. I tell all of my clients, look, if we sign this form on May 15th, put it on your calendar. Every year, take out your copies of your forms, look at them, and see if it still reflects your current situation. And for my clients, not people who aren't my clients, but if they're my clients, I do tell them, if you want to call me every year or every 2 or 3 or 5 years and say, hey, has anything changed in the law? I'm happy to look at it and say, hey, if nothing has changed with you financially or healthcare or otherwise, there hasn't been a change, or I do recommend there is a change, we, should do that. But otherwise, there's no way you're going to be able to know. There's no list. I spend probably about 40 hours every year on continuing legal education, and I pay thousands of dollars for it just to try to keep up to date. And some people will say, well, Jacob, as I said, that's great, but I've already done my forms. Well, as I pointed out, you might need to change your forms if something has changed with your circumstances, financial, health care, the circumstances of anyone you've appointed to make your decisions, your beneficiaries. One of my clients just called me. They said, well, we're supposed to sign our trust in a week or something with you, but one of the beneficiaries we listed, she just died last week, so we probably want to make a change before we sign this. I said, yes, that's probably a good idea. But Illinois law has substantially changed. January 1st of 2020, the state of Illinois massively overhauled the trust law. Before, the trust law in Illinois was called the Illinois Trust and Trustees Act. It's now called the Illinois Trust Code. And I cannot even begin to go over all of the changes that were made. And some of my clients will say, well, what happens if I don't change it? And my answer is, look, if you've done estate planning, you've done this to make it a smoother, easier, simpler transition for yourself, your friends, your families, your charities, etc. By keeping things up to date, the chances for a problem are going to be minimal. If we don't, you're going to take your chances. I won't say there's no way on earth it'll work, but a lot more chances for problems. I've had a few problems with clients who have not updated their trust. I've had a lot more problems with powers of attorney with clients who had pre-2011 forms and just wouldn't update them. So I do suggest it's very important to keep your forms up to date. And for a lot of attorneys who don't do this type of work all the time, they don't even know that the trust law has changed or that the powers of attorney for healthcare and property have been updated. That's pretty regular because a lot of attorneys just are using that same form they've been using for 10 or 15 years. But if they don't do it, they're not studying it. Also, if that wasn't enough, and this was right around the time we'd all like to forget, which is COVID, December of 2019, the federal government enacted something called the Secure Act. I like to say it makes me feel anything but secure. This affects retirement accounts, things like IRAs, 401ks, 403bs, etc. Prior to this, you could leave anyone as a beneficiary and he or she could take those money out and it could grow tax-free over his or her lifetime. Now, only your spouse can do that. Anyone else, or almost anyone else, they only usually have up to 10 years to take all of that money out. So the advice that I or somebody else might have given you prior to December of 2019 regarding your retirement accounts might be vastly different because of the change in the law. We can also briefly talk about estate taxes. Some people come to me, they said, well, I've heard if I don't have a trust, that means the state is going to take all of my money. I assure you the state of Illinois is not going to take all of your money. It's just if you live in the state of Illinois, it only feels like the state of Illinois is always trying to take all of your money. However, if you have significantly less than $4 million in the state of Illinois in 2026, your estate is not subject to estate taxes. But I mean everything that you have, either you personally or if you're married, you and your spouse, if you haven't done any estate tax planning. But that $4 million includes everything. It includes your real estate. It includes your IRA, your 401k, term life insurance, cash that you have at home. It includes everything. I don't care if it lists a beneficiary. A lot of times people say, well, my IRA has a beneficiary. I tell them, you're confusing your issues. That's not probate. This is estate taxes. And if you have an excess of $4 million, the state of Illinois does not tax what you have in excess of $4 million. They tax the full $4 million plus on a graduated scale like income taxes. I had a couple who called me and they said, well, the lawyer we spoke to before, said we don't, and did our wills. He said we really didn't need any trust. I said, well, for most people, maybe you didn't need it, but it'd probably be beneficial. I asked them, how much do you have between both of you? They said, well, we have $5.5 million. I said, well, that means if you don't have any estate tax planning, if you both die and your estate doesn't grow any further than the $5.5 million, your estate's going to be paying $350,000 when you die. Needless to say, it was pretty easy for me to convince them that they needed to do some advanced planning. Now, if you are married and you plan correctly, you can avoid estate taxes on up to $8 million. Federal taxes don't come into about $15 million. It doesn't affect too many people. Anything in excess of $15 million taxed around 40%. State of Illinois, the maximum threshold is 16, but that can still add up to a lot of money. Now is the fun part of today's program, learning from celebrities. You can learn about what good or bad they did so you don't have to make the same mistakes. First one we'll speak about today is Michael Jackson. I remember when he died, all of the newscasters read something from his documents. He was previously married, so it said, I have intentionally not provided for my ex-spouse so-and-so. She is to be treated as dying before me. Now, all of the newscasters read it very solemnly, like why did the attorney put such harsh language in there? But I guarantee you every estate planning attorney knew the answer, or every estate planning attorney who knows what he or she is doing. Because if you don't write that in and you have somebody that might be a problem, you do need to exclude them, and there is a correct way of writing it. If you have a son and a daughter, it's not enough to say, I give everything to my son, end of story. The daughter can come back and say, well, my parents didn't know what they were doing. The attorney made an error. But assuming that the people who wrote it, they were in the right time when they wrote it, and there was no undue influence, yes, good luck trying to refute a document where on the first page it said, I did not want to give you anything. Extremely difficult. Robin Williams. Well, he had a trust done, but either the attorney didn't give him great advice or he did it when he was much younger or before he had many assets. His children were to receive all of the money at the age of 21, not a great idea for most of us, let alone somebody who had an estate the size of Robin Williams. Also, he did have a successor trustee, somebody to take over the management of the trust when he died or became disabled. Unfortunately, he only had one person. That person died before he did, so his estate still wound up going through the court process. Philip Seymour Hoffman. During his lifetime, he gave a lot of money to a lot of good charitable organizations. But when he died, because he was not married to his significant other and he only had a simple will, the charitable organization that received the majority of his assets, it was the IRS. Michael Crichton. Well, here's a famous author. Perhaps before you go, you can take one of his books out from the Morton Grove Library. But perhaps he left us with a mystery. He didn't even contemplate when he was writing his books, who did he want to have inherit his estate? When he died, his trust left everything to a child from a former marriage. But the last thing I heard about this, his most recent wife, which was his third marriage, she was suing his estate on behalf of their unborn child because she was pregnant with his child when he died, but he had not updated his trust. Mickey Rooney. Well, I'm a movie buff. I like to watch anything from silent film to a blockbuster today. But unlike today's movie stars who are only married 2, 3, or 4 times, Mickey clearly could not get enough of a good thing. Because when he died, he wasn't on his first, second, third, fourth, fifth, sixth, or even 7th marriage. He was on his 8th. And the 8th is the one that really did him in. At some point, she and her adult son managed to imprison him in his own home, and they stole all of his money. He eventually was able to escape. The judge ruled that the money had to be returned, but he died before he ever had a penny of it or saw a penny of it back. If you're on your 2nd, 3rd, 4th, 8th marriage, maybe that is not the person that you want to appoint to be making your healthcare and financial decisions. Now, while this sounds outlandish, I do have a number of clients where maybe neither of them have any children, maybe one or both of them have children from a prior marriage, etc. And the concern may be, well, if something happens to B, well, I can leave everything to you, but, you might give everything to your friends, families, and charities, or even a new spouse, leaving mine out. And that is a realistic concern. So I tell my clients, that's one option for you. You can say when you die, some of your assets go to your spouse or significant other, some go to your friends, families, or charity. Or you can choose the more complicated, slightly more expensive route where you can say, if I die, my money can be held by a separate trustee for the benefit of my spouse if he or she runs out of funds, and the money can be used for him or her at that point, but any money left over at the time of my spouse's death will go to my friends, family, and charities, not my spouse's. So you have a number of different options on how you want to approach something like that. Prince. Now, during his lifetime, he was actually supposed to be a very smart guy. He fiercely negotiated all of his contracts. During his lifetime, you were not going to get his content legally for free. But when he died like an idiot. No will, no trust, nothing in place whatsoever. When he died, he had no children. He was not married. His parents were deceased. He had no full siblings, but he had a number of half siblings. Legally the same as full siblings. But because he had no estate planning documents and he had a rather large estate, it took more than 8 years to settle it due to litigation, hard to value assets, etc. And during that 8-year or so period, the only people receiving money from his estate, accountants and lawyers. At least some of the money was going to a good place. Jim Morrison, he was the lead singer from The Doors. Before you could make one of the worst decisions of your life and or death and download something from the internet, you could get these from a stationery store. Me and every other estate planning attorney and every judge in probate, we've all seen self-drafted forms. You're not fooling anyone. We know it was not drafted by a lawyer. We usually have to withhold our laughter because it rarely ever says what our clients think it says when they drafted it. And he basically said, well, he just had a will where it said everything went outright to his wife. Well, within 6 months of his death, she died too, with no will. And when he died, it became hers. Well, when she died, she had no children. Obviously, she was no longer married. She had no siblings, living or deceased. Her mother was deceased, but her father was still alive. So within 6 months of Jim Morrison's death, his entire estate wound up going to his father-in-law. Probably not what he anticipated. It could have gone a little smoother with some better drafting. Aretha Franklin. I guess for years her attorneys were trying to get her to do a will or trust or something. But she was a private person. What do I mean by that? She didn't want to tell her attorneys how much money she had. And that can be a real problem for anyone trying to do your estate planning. Because every now and then somebody tells me, well, I don't want to tell you how much money I have. Keep in mind, as a lawyer, we're legally prohibited from telling anyone else how much money you have, unless you die or unless you actually consent to it. But when she died, apparently they thought she had no will, but in her residence, squirreled away somewhere in a desk drawer, I believe, she had drafted a will herself. A few months later, in one of her other residences, they found another will she drafted herself. I believe it was in a couch, only causing more problems and more litigation for her estate. Edgar Bergen, he was Candace Bergen's father. Candace Bergen was probably best known for a TV show known as Murphy Brown. But before she was famous, her father, Edgar, was actually a fairly famous ventriloquist. And this can be used to show you don't have to treat your children equally. When he died, he left Candace absolutely nothing, but he did leave $20,000 for the preservation of his ventriloquist dummy. There were even rumors that growing up, the ventriloquist dummy had a larger bedroom than Candace. Now, this can be applied to show, as I said, you don't have to treat your children equally. Well, some of my clients say, well, my son is doing very well, my daughter not so much. We want to leave more or all of our money to our daughter. And I say, it's your money, you can do whatever you want, but before you actually do that, make sure this is what you want, because there's a very realistic possibility they will never speak to each other again. On the other side of the coin, what if you've given one of your children more money than the other? Maybe you've given them money for a house, maybe their education, a business. And usually what happens is they'll say, don't worry, mom or dad, when you die, I'll make sure all of my siblings get $100,000 or $200,000 more than me. Well, I've been practicing more than 20 years, and I've concentrated in estate planning the full time. I have never seen this happen. And if you don't have a promissory note, or if it's not reflected in your estate planning documents, it's just going to be a gift, and there's a 99.9% chance that's what's going to happen. I realize everyone likes to think the best of their kids. While blood is thicker than water, it's not thicker than gold. Don't take a chance if that's what you want to accomplish. For those of you who say, I'm too young to do my estate planning, I'm just here because I need to help my parents plan, or my elderly friend or aunt or uncle, look at Britney Spears. She had multiple mental breakdowns. Her father was appointed as her guardian. It took her years to get him replaced by a corporate guardian. But if she would have just had powers of attorney for healthcare and property in place, none of that would have been necessary. And I don't know why, ever since COVID began through today, I've had a lot of clients who have had issues with young adult children. A lot of things with gambling, drug addiction, mental health issues, etc. If you drive regularly, what I think pre-2020 used to be the craziest thing you ever saw on the street, that's just another Monday. Because even yesterday I saw somebody do a turn and I had to scratch my head and say, did I really just see what that person did? Yes, I did. It didn't result in anything, but I've also seen some pretty horrific car accidents in my day. So for that reason, a good idea, even if you're relatively young, to do at a minimum powers of attorney for healthcare and property, but sometimes even a simple will in addition to that can be a good idea. I had one client, his son had tragically died apparently. His son thought it would be a good idea to hold on to the outside of his friend's moving car while he was on a skateboard. Well, the car ran him over, killed him. We had a settlement for a little over $1 million, but because he had no will, the $1 million went a fourth to my client, a fourth to my client's wife or his mother, and a fourth to each of his two minor siblings, a 14-year-old and a 16-year-old. And the client said, is there any way to prevent my kids from getting $250,000 when they turn 18? I said, unfortunately, there really isn't. You can argue with the Illinois legislature, but that's the law, and your son didn't have a will. If he had a will, he could have said, if something happens to me, it all goes to my parents, or maybe if he had a will and a trust, I guess maybe it could have been withheld for his siblings until they were older ages. And heck, well, when she died, one of her former significant others said that some emails between them constituted a digital will. The courts did not find in his favor, but Illinois is one state that does recognize it. But what is a digital will and how does it work? Did you sign it when you were in Illinois? Where were the witnesses? Where was the notary? Does this only exist in a digital format? Did you sign it in ink? Maybe the witnesses or the notary signed it digitally. While it is allowed in the state of Illinois, it is relatively new law, and the courts don't necessarily have the ability to accept a digital will yet. Well, I think this is the way of the future, and this will probably be the way that I and every attorney does it. I want the other attorneys and their clients to be the guinea pigs. I'd like to do it with a pen and paper, the way I know it's been done and the way I know it'll work, because I just had one client, I think it was actually my client's daughter, and she said, I want to make sure we do everything over the internet and with VeriSign. I said, look, that's fine for real estate closings, but for this, don't do it. If you want, you can pretty much find a different attorney, but I don't really want to be the guinea pig and be sued when it goes wrong, and I assume there'll be a lot of problems with this in the near future. Also, a lot of problems probably with fraud with something like that. For those of you who say nothing like this will ever happen to me, look at one of Chicagoland's very own, Joseph Stankak. When he died, he had a relatively simple life. He lived in a small bungalow, but he died with $11 million. When he died, he was not married. He had no children, no siblings living or deceased, parents deceased. I don't believe he had any aunts or uncles or any living. And a lot of people will say, when I ask them, do you have any family members? A lot of times people say, well, I have no family members. That's not true. You have somebody somewhere. And the issue is when he died, well, his estate wound up going to 119 of his nearest and dearest family members. Those were his heirs at law, probably as determined by the state of Illinois or the Probate Act in Illinois. And even though he might have not had close friends or family, wouldn't this have been a little bit better if he had a will and a trust? He could have given this money to good charitable organizations, things like maybe an animal rescue, maybe an educational facility, maybe something like his local library, maybe to feed the homeless. There are a lot of good causes that really could use the money, as opposed to the money going to 119 individuals who he probably never heard of, and they probably never heard of him just because of some distant relation. Coolio, also known as Artis Leon Ivory Jr., he was best known for a single known as Gangster's Paradise. I remember it used to wake me up every morning on my alarm radio when I went to high school. But when he died, he had no will. He had 7 adult children, all of whom he had with 7 different women, none of whom he was ever married to. They all have the right, an equal right to 1/7 of his estate, and they all have the equal right or standing to be the administrator of his estate. You can imagine what a fun probate estate that's going to be for some lawyer. Pablo Picasso, when he died, he had no will. He had over $30 million. It took more than 6 years to settle his estate. More recently, James Van Der Beek tragically died. He was only 48 years old. Apparently, his friends and fans did a GoFundMe campaign to raise some money for his poor family. I think they raised $1 to $2 million for them because his poor family only had $5 or $6 million of their own. Don't plan that somebody is going to do this for you or me. It probably won't happen. We'd probably prefer to be a little bit more like Robert Duvall. When he died at 95 with a little over $100 million. I think I missed one. Kurt Cobain tragically died at 27. He was from Nirvana. He wanted all of his money to go to his band members. He wanted to get divorced from his wife, Courtney Love. But because he was still married to her and didn't do any estate planning, she received everything when he died. More recently, Nicholas Brendon from Buffy the Vampire Slayer, the TV show, not the movie, passed away from natural causes at the age of 54 with an estate of about $300,000, and Chuck Norris died at 86 with about $70 million. And I'm using this to illustrate we don't know when we're going to die, and we don't know how much money we're going to have when we die. But by keeping your estate plan up to date and doing it earlier and updating it to reflect changes, this can reflect all those different situations. It's just if you don't, the estate might not go so smoothly. Now, while I realize we went over a lot of information today, don't be overwhelmed. All you really need to do to start your estate planning, you should have an idea of what your assets are and what they're worth, who your beneficiaries are, or at least some idea of your beneficiaries. Some of my clients say, well, I think it'll be 5 people and 5 charities. That's fine. And contact a good estate planning attorney. Let him or her know what you want to do. That's really all you need to start your estate planning. Now, before I open it for questions, just a few last items. So as I said earlier in today's program, but a few people came later on, today's program is for informational and educational purposes only. Nothing today is or should be considered legal advice. If somebody asks me a question that sounds like legal advice or is fairly detailed or particular, I'm going to politely decline to answer that. I cannot give legal advice here. Also, there's one question I know I get at every program if I don't cut it off at the pass. How much is this going to cost me? Well, if you were able to tell me how much money you had and what you wanted to do in front of everyone else, maybe I could tell you, but realistically, this is a library, I couldn't do this. And if you ever call up an attorney and say, how much does it cost for a trust, and they tell you without spending enough time, they'll do you a disservice and themselves a disservice because they're not going to know what you need. The way I generally work, I tell people, you can call me, you can make an appointment with me in my office, you can see me up to an hour. I'll say, based on what you have, based on what you want to do, this is what I recommend. You'll sign a contract when we meet initially. You'll pay me half up front, the other half when you pick up a draft from me. That's as fair as I can be, but I think any good lawyer needs enough time to figure out what's going to be appropriate for your particular situation. And that's all I'll speak on about that specific topic. So if you do have any questions, I do suggest you raise your hand and ask questions. This will be the last time you get to speak to a lawyer for free.